All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention. You will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. We're going to kind of do an unusual thing today. We're going to hear our first case. We'll take a brief 5-minute break. Then we'll hear our second case. And then we're going to hear some remarks from Justice Kennedy, who as we all know, is going to be retiring from the court at the end of this month, and today is his last oral argument, and so we'll handle that at the end, but I just wanted to let people know in advance what we're going to be doing. Our first case today is AC versus State, number 2025-0612.
Mr. Chief Justice, and may it please the court. Good morning. My name is Nicholas Lynch, and I'm here on behalf of the petitioner AC. I've asked the court to please reserve 5 minutes for rebuttal. As a middle schooler, my client smeared deodorant on his teacher's laptop, desk, chairs, and the floor of her classroom, and the state prosecuted him for the crime of culpable negligence. In Green, this court made clear that this crime requires proof of reckless indifference or grossly careless disregard for the safety of others. But the district courts of appeal are split on how to hold prosecutors to this standard. The first and second districts hold that this crime requires proof that the defendant knew or should have known that his conduct created a likelihood of death or great bodily harm. But the third district in this case rejected that standard and held that my client's conduct rose to the level of criminal culpable negligence. I'm here to ask the court to affirm the standard or approve the standard from the first and second districts in Kish and Azima and reverse the third district's decision in this case. Kish and Azima got it right because their standard is clear and prevents absurd and unconstitutional outcomes. Their standard clearly explains what level of negligence is sufficiently wanton, reckless, and egregious to rise to the level of a crime.
When we describe negligence, though, we're typically describing a state of mind, right?
We're describing
a heedlessness of risk.
Yes, the failure to show the ordinary duty of care.
Okay, can we establish whether we are, when we discuss culpable negligence as opposed to other types of negligence, we are necessarily also speaking to the eventuality itself, that is the risk of what? The type of harm. Because it would seem to me that the rule you're proposing sort of freights the idea of negligence with not just a heedlessness of risk or a disregard of a substantial likelihood of harm, but also it speaks to the nature of the harm. And I wonder if you can direct us to support for that position either in the statutes or in the cases.
Yes. So in Green, this court explained that culpable negligence is an act or omission that creates an unreasonably great risk of harm to others. So the risk of harm to others is built into the standard. It's not just heedlessness of risk. And it's not just
Right, but I'm asking about the content of the harm. I'm talking about, I'm asking whether in the definition of culpable negligence at common law or under the statutes, the serious likelihood of serious bodily harm or death is baked into the state of mind itself.
Yes, I believe it is. It's not defined, the legislature hasn't defined culpable negligence, but the case law...
Can you direct us to the best support in the statute for your position?
The best support in the statute is, so turning to the text of the statute, my client was prosecuted under section 78405 subsection 1. The text of that subsection provides whoever through culpable negligence exposes another person to personal injury commits a misdemeanor of the second degree. Notably, the legislature made a purposeful textual choice to require both culpable negligence and exposing another to
But
personal
all it
injury.
says there is to personal injury, right? It doesn't say grave personal injury. It doesn't say serious bodily harm or death. The context in which you've just articulated the type of negligence seems possibly to me to cabinet to personal injury. Like that's all that's all the risk had to be. That's all the possible harm had to be. Tell me why I'm wrong.
So, Your Honor, I think that's wrong because the legislature required both culpable negligence and exposure of another to personal injury. And when we look at Kish and Azima and compare the standard in the first and second DCAs with the standard in this case, the courts are required to interpret statutes in a way that avoids calling their constitutionality into doubt, and Kish and Azima do that. The third district's decision in this case does not. In this case, the third
What's the
district.
constitutional issue, though? Because, I mean, we have strict liability crimes. I mean, so let's refocus you on, so the relevant language here, or at least the starting point has to be getting our minds around what culpable negligence means, right?
Yes.
Negligence in general refers to the creation of an unreasonable risk. Okay?
Yes.
Right? So the culpable part, I think, signals, and I think that what Green was getting at is that there's sort of an elevated, when they talk about, you know, a great risk, it basically kind of increases the probability of the harm from just the, you know, sort of the unreasonable risk to a great likelihood that whatever the risk is that you're worried about, in this case, personal injury, is going to occur.
That's
Okay?
exactly correct, Chief
And
Justice.
to the extent, it seems like the court also, when they say that reckless indifference or grossly careless disregard means, it's possible that what it's talking about is that the quote-unquote mens rea, or the state of mind, is that unlike some negligence that can occur when there's just sort of careless behavior, you know, you're driving and you reach over to grab something and you get in an accident. In the recklessness context, the negligence, i.e. the creation of risk, has to be intentional. And I'm wondering if the way to kind of understand culpable negligence, the statute obviously signals to you that the harm that you're worried about exposing people to is personal injury. But if you focus on the culpable negligence thing, it seems like it's drawing your mind's attention to two things. One is whether you're creating the risk through intentional behavior as opposed to carelessness, i.e. culpable. And then the culpable negligence combined, the idea that the risk has to be greater than just the sort of the regular amount of risk. So if we turn to this, what evidence in the record was there that your client's action was intentional, or what, if any, evidence was there that he intentionally put the gel or whatever on the floor? Because obviously the floor is the only thing that relates to the potential of personal injury, right?
Yes. So the evidence in the record that he intentionally did that, there's no evidence that he intentionally caused that harm or sought to cause anybody to slip.
There's a difference between sort of wanting a specific result versus intentionally, you could be carrying a bucket of gel or whatever and drop it on the floor, and then how you react to that may be sort of negligent or not negligent. But I'm just wondering if there was any evidence that he had intentionally put the stuff on the floor.
So the teacher testified that she asked him, did you do this? And he said yes. That's the state's evidence in this case.
Okay. So then on the aspect of how high the probability of personal injury was, what was the evidence on that?
The teacher testified that she thought that the deodorant created a safety risk in her classroom, and the officer, who was the state's only other witness, testified that if she walked over it, she thinks she would have slipped too.
So do you think that's Is that how high of a problem? What does that establish?
I think that establishes simple negligence. I think if this teacher had sued my client for negligence, she could have prevailed on a simple negligence suit, but I don't think she could have established punitive damages by proving gross negligence or culpable negligence, which is what's required. And Green is significant because that's where this court held that it's committed to the rule that to impose criminal liability for negligence, the degree of negligence needs to be at least as severe as it does to warrant punitive damages in a
So for
civil
your
case.
client to win, you don't need to prevail on the issue of whether it's actual, what is it, death or serious personal injury or something. What's the test from the two conflict cases?
So Kishin Azima required the state to show that the defendant knew or should have known that his conduct created a likelihood of death or great bodily harm. And I agree, I don't need to prevail on the conflict issue in order for this court to correctly reverse and remand with directions to discharge my client.
And don't you think that, I mean, doesn't the text of, I understand that sort of defining culpable negligence, it has to be informed by the personal injury, but it doesn't, I mean, it is kind of its own separate concept. But don't you think that having the exposure to personal injury and then the next subsection saying that if you actually cause or if personal injury ensues, doesn't that textually make it hard to bake into the concept of culpable negligence that there be death or serious bodily harm?
I don't think so. I think the legislature in subsection 1 used the phrase exposes another to personal injury to distinguish subsection 1 from subsection 2, which requires proof of actual injury being inflicted. And I think that reflects the legislature's intent to criminalize culpable negligence in all contexts, regardless of the outcome. This is part of a larger statutory scheme under which Florida has comprehensively criminalized culpable negligence, but affixed different penalties depending on the outcome of the culpable negligence and who the victim is.
Would you concede that your client inflicted rather than exposed here?
Yes, but under both theories of prosecution, subsection 1 and subsection 2, the legislature also required proof of culpable negligence by including the phrase through culpable negligence.
I guess part
and
of
that's
the
what's
work,
missing.
one hypothetical that's been suggested is imagine instead of smearing deodorant, imagine if your client had spilled a milkshake on the floor, right, and not cleaned it up.
Yes.
Right. That, it would seem to me, both from a decision made by the defendant, that is not to remedy something, is different from purposefully introducing a source of risk into the environment. Would you agree that that's the line between exposure and infliction for the purposes of distinguishing between these two different misdemeanors?
No, I think the distinction between exposure and infliction is just the degree of the penalty that the legislature intended based on the outcome.
I understand that that's obviously a difference between the two degrees of misdemeanor. I'm sorry if I was imprecise. Distinguishing what types of conduct fall into one bucket or another.
I don't think that gives us a very workable standard, and I think when we apply the...
So give me one.
So I think the first and second district standard requiring a likelihood of death or great bodily harm that the defendant...
Yeah, but that's not the one I'm talking about. I'm not talking about the degree of harm. I'm talking about whether conduct constitutes exposure of a person to risk versus inflicting an impact on the person. The difference between subsection 1 and 2.
I mean, the difference is the consequence, right?
Yes.
In the first one, the person isn't actually harmed, but he was exposed to harm. And in the second one, they were harmed. In this case, your client was just charged with the exposure rather than the infliction.
Exactly.
But obviously, if the other side is right about what culpable negligence means, then they could have charged your client under the second one.
Yes, the outcome of this case should not depend on which subsection he was charged under, because the culpable negligence element is what was missing.
In looking at the facts here, I'm looking at it from a perspective that this is just some stunt some student did to a teacher. I guess the intention was for the teacher to fall, and then everybody laughed, and that's it. I don't know that he intended that she be injured.
So
I'm trying to think of it in the context of comparing that to doing some stunt that you just want to show something really fast to a teacher, or something in a box, something in a container that contains something that would be offensive or whatever, and the teacher or whatever opens it up and has a heart attack and drops. I mean, the intention was not to kill, not that the person have a heart attack, just to scare them. It seems to me here the intention was that the teacher just fall on her rear end and everybody laughed.
So I don't quite agree with that, Your Honor. I don't think that his intention is clear at all from the record. If this was a case where he put oil or soap or something typically thought of as slippery on the floor and lied in wait recording a TikTok video and it was a prank and it was clearly intended for his intent was for the teacher to fall, that would be a totally different case. The evidence is that he smeared a stick of deodorant over the teacher's laptop, desk, chair, all over, and then held up his hands and asked if he could wash them.
So on the foreseeability issue, you're talking a little bit about, to the extent that that's likely, how likely that is to result in injury. Would you agree that we would need to decide that if this case was decided on that issue, that would also need to be as a matter of law? Correct. I mean, I think you said that you disagreed that it was foreseeable in this context that somebody would get injured, but what legal basis would we have to say, as a matter of law, that type of foreseeability is not sufficient to rise to the type that's presumed by culpable negligence?
So I don't think the standard is foreseeability. I think it's whether it's not whether personal injury is possible. The question is whether personal injury is likely. If death or great bodily harm is likely. And that's what the second DCA wrote in Azima. It's the likelihood of death or great bodily harm that justifies imposing criminal sanctions. And I think when we apply the two competing standards to different facts, we really see why constitutionally the correct interpretation is the one from Kish and Azima. So turning back, Justice Carrillo, to your spilled milk example, we could think of a case where maybe a grocery store employee is mopping the floor. He's in a rush to get to his lunch break, and he decides he's going to cut corners and not take the time to set out a warning slippery floor sign or otherwise warn customers of the risk he's created. That employee has created a risk a safety risk to the public. And while death or great bodily harm could occur there, it isn't likely. So prosecutors and judges shouldn't treat it as a criminal negligence that's punishable by jail time. And the first and second district standard is the only one that ensures that they won't. And we could also look at the facts from the cases from the first and second DCA where they developed this standard. And we see that if they hadn't imposed the requirement of the defendant knowing or disregarding a likelihood of death or great bodily harm, the outcomes of those cases would have been absurd on their facts too. So for example, in Azima, that doctor would have faced jail time for simply not using a more accurate pregnancy test than he used. Courts are supposed to interpret statutes in a way that doesn't call their constitutionality into doubt. This court has been clear.
But what's the constitutionality? What are you talking about?
Oh, so this court has been clear that the state cannot criminalize simple negligence, and that's really
That it can't or that it didn't?
that it cannot. The government cannot criminalize simple negligence. And the third district's opinion in this case
Is that a due process issue?
Yes. Yes, and that's discussed in the Winters case in my brief. I see I'm running out of time. I'd like to talk about why the standard I'm advocating doesn't conflict with the statutory text. I know that the state wants to begin and end the analysis with the fact that in subsection 1, the legislature used the phrase exposes another to personal injury instead of exposes another to death or great bodily harm. I think the reason the legislature chose that language is to clarify its intent to impose criminal sanctions for culpable negligence, regardless of the outcome of the case, and they wanted to ensure that people who engage in unreasonably dangerous conduct can be prosecuted even if, just by good fortune, nobody gets hurt. So I think a game of Russian roulette is a helpful example for understanding that. And also understanding how this statute fits into the broader statutory scheme. So if the first player in a game of Russian roulette takes a gun, pulls the trigger, and kills another player, that defendant has committed manslaughter. If the second player takes the gun, pulls the trigger, and it misfires and causes just a gunpowder burn or grazes the other person, that defendant has committed the first-degree misdemeanor under subsection 2 of the statute because through culpable negligence he has inflicted actual personal injury. And I think the reason the legislature used the phrase exposes another to personal injury in subsection 1 is to ensure that had a catch-all where it could prosecute a third situation, which is where somebody picks up the gun, pulls the trigger, and nothing happens. That defendant has still, through culpable negligence, exposed another to personal injury, even though no personal injury actually resulted. And I think that language in subsection 1 makes clear the legislature's intent to ensure that that defendant can still be prosecuted.
But in your hypo, though, then you create this weird dissonance where the risk that culpable negligence is referring to is death or great bodily harm or whatever, but then you're saying that the consequence that actually ensues could be met by a lower level of physical injury, the gunpowder burn. I mean, I think that part of what's going on is that while everybody recognizes that culpable negligence, has some content that we have to sort of get our minds around, the question is, how do you relate the content of whatever that is to the choice by the legislature to talk about personal injury? They could have said in subsection 1, they could have said if you through culpable negligence expose someone to serious death or whatever. In section 2, they could have said through culpable negligence actually results in, whatever. And so you're asking us to bake this really high standard into culpable negligence, but then say that you can meet, when it actually does result in harm, that you can meet that through a much lower amount of harm. And that seems counterintuitive.
I don't think it's counterintuitive because culpable negligence is a legal term with a consistent meaning across all other criminal statutes, and there's no indication in this statute that the legislature intended the phrase exposes another to personal injury to alter the meaning of culpable negligence in this one statute and make it different from the rest of Florida law, like the 3rd DCA held. I see that I'm out of time.
You can have 2 minutes for rebuttal, then 30 seconds to finish up here.
Thank you, Your Honor. The standard for culpable negligence is consistent across the different criminal statutes that use this term, and it's also consistent with the punitive damages standard in civil negligence suits, which is important because in Green, this court said it was committed to the rule that the degree of negligence required for convicting someone under this crime is at least as high as the degree of negligence in a civil negligence suit. Just this past summer, in Tesla versus Banner, the 4th DCA held that a decedent's estate could not obtain punitive damages against Tesla because the plaintiff could not show that Tesla knew or should have known that it created a risk of death or a likelihood of death or great bodily harm. The 4th DCA pulled that standard.
Okay, sorry, you're going way over, so thank you. 2 minutes for rebuttal.
Sorry, Your Honor. Thank you.
Mr. Chief Justice, and may it please the court, Daniel Colmenares on behalf of the state of Florida. I would like to begin by correcting a little bit of a confusion regarding the punitive damages standard. As my colleague Mr. Lynch was just discussing, he's discussing this case Tesla, which apparently held that there was supposed to be a likelihood of death or great bodily injury to punitive damages in a civil suit. Well, I think our legislature would be quite surprised to hear that because the punitive damages statute makes no mention of a likelihood of death or great bodily injury. I think
the reference to the punitive damage, that goes back to 1920 case law from this court about culpable negligence in the context of criminal cases.
That's right, Justice Sasso. In fact, that case canon is 1926. And there the court was equating the level of negligence required to sustain criminal liability. And it said at least on the level of punitive damages. And that's where we get the language of reckless indifference or grossly careless disregard for the safety of others. That's what this court has said for the last almost 100 years now. And it's that standard which is most consistent with the ordinary meaning of the term culpable negligence.
So it seems like if you read the third DCA opinion, it's going along fine, it makes sense, and then it finally gets to the last paragraph where it actually has to apply the standard, and it doesn't seem like it's really doing anything other than looking to see if there was evidence of ordinary negligence. So can you explain to us in the context of this case, even if you're right about reckless indifference, first tell us what you think that means and then connect it to the actual evidence in this case?
Sure, Your Honor. So first, reckless indifference for the safety of others. When we're talking about this standard, what we're essentially saying, and what Cannon, Russ, and Green have said, it's almost as if there's an intentionality behind it. It's not quite the intentional conduct.
Intentionality to create the risk or to actually harm the person?
To create the risk, Your Honor.
Okay.
And so the record evidence in this case actually does show that AC acted with reckless indifference for the safety of others. Why? The amount of deodorant gel which was spread here all over the floor, and not just the floor, but all over the sides of the tables and the desk. Yes, the floor is what actually exposed, but the fact that it was spread all over the tables, between the aisles of the tables, that shows that this was no accident. That shows something more akin to intentionality, because any reasonable, prudent adolescent, because AC is 14 and a half years old at this time, any reasonably prudent adolescent would know cause and effect. If you cause a surface to become slippery like that, especially the amount of deodorant gel which is brought here, that's going to lead to exposure to personal injury.
So how much though was, because my understanding of the record is that the gel on the floor was not, what does the evidence show about the sort of the extent of the surface and the visibility? Because it seems like if you're talking about an exceptionally high likelihood of the injury occurring, it seems like it's being pretty loose to just say, quote unquote, all over. I mean, I thought that the record was that it was in a pretty discrete area.
Right. Chief Justice
for the floor.
Yes. First, I would like to go back. It's not the high likelihood. There's no standard of high likelihood. That's the standard that my colleague is proposing. Here it's mere exposure, but the recklessness is, wanton carelessness.
Right. But I mean, as a matter, if you look at the restatement of torts, for example, when they're talking about recklessness, it's a combination of intentionality and a very high degree. Not obviously, if it gets to the point where harm is certain to occur, then you've crossed into you can infer that the person intentionally was trying to harm them. The gap between negligence and intentionality, though, where recklessness fits in, is where basically there's more than just a probability of harm, but there's a high likelihood of harm. That's if you're looking at it through a recklessness lens, which it seems like that's what Green is telling us to do.
Right. What Green is saying is it says to criminalize unreasonably large risks of harm.
Right. Unreasonably large. So
yes,
as opposed to unreasonable risk of harm, unreasonably large risk of harm, not unreasonable risk of large harm.
Right, Your Honor.
Right?
I take your point. Now, the record evidence which does show this is the fact that there was testimony from the officer on page 120 of the record that she saw a clear coat of gel on the floor, and there were some lumps which appeared to have formed from the result of that amount of deodorant gel which was spread.
What's that evidence of?
That is evidence of the reckless disregard, Your Honor. That's the culpable negligence standard which Green has set forth.
How is that, though, evidence of the foreseeability of harm, though? Because there has to be the intentionality of the act, but also that act would lead to the harm. Otherwise, it's not negligence or culpable negligence, right?
Correct, Justice Sasso. The foreseeability is when you spread a surface as slippery as deodorant gel or oil or milk or any of the like, it's going to lead to someone to slipping and falling. That's okay, probably.
And so I think that's what we're trying to get at. What is the evidence in the record? It's just merely the extent of the evidence is the deodorant on the floor, period. And then from that, every reasonable person knows that if you spread deodorant on the floor, you're going to fall, kind of as a matter of law.
It's both the evidence of the amount of gel and also the testimonies of Ms. Menikow and the officer who said, I could have slipped in this. That's credited by...
But it's also a matter of where, right? I mean, part of the, if you're talking about an unreasonably high risk of harm, you know, if I'm putting it right in the middle of where everybody normally walks versus if I put it in a corner, you know, arguably the more obvious it is, the less, you know, if I do something that's just so blatant that I'm, you know, I might think, haha, whatever, maybe my friends will think it's funny, but no one's going to be dumb enough to actually walk through that. I mean, have I created an unreasonably high risk of harm? I mean, it seems like the evidence in this case really just shows, I mean, A, the evidence on the intentionality is either weak or absent. But B, as far as whether, you know, whether there's an unreasonably high risk of harm, it's obviously if you spill something wet on the ground and it's a place where there's any possibility, you know, of people walking there, you've created a risk of harm. But as far as the probability of the risk of harm, even if you take away the severity of the harm, but just the probability that there will actually be harm, it doesn't really seem like there's much evidence on that.
Your Honor, two points as to that. The culpable negligence standard is judged from an objective standpoint. And so you look at whether a person knew or reasonably should have known that harm would manifest. And so when you do put it on, like as you said, on the science classroom floor where it's been trafficked, and the record also shows that, you know, this was in between class changes. So not just the teacher was exposed here and could have slipped on it, but many other students could have traversed. And so the amount of people that were in that classroom, it's not, like you said, an isolated corner of the room, or it's just a one-on-one conversation with the teacher. The fact that multiple students, and these were ESC students, that could have walked through there and slipped and been exposed to injury, plus the amount of deodorant gel, plus the testimony of the teacher and the officer saying, we could have slipped through this caused a safety concern.
Okay, well that doesn't get you really anything more than just negligence.
I disagree, Your Honor, because, again, the distinction between simple negligence, and I would like to make clear that neither the Third District nor the state is advocating that a simple negligence standard would suffice. It's the reckless indifference for the safety of others. And in the light most favorable to the state, this is on a motion for judgment of dismissal. All the reasonable inferences drawn in the state's favor, there is that record evidence sufficient to support the reckless indifference for the safety of others.
The defendant here wasn't trying to hide it. I mean, it sounds like he was, you know, okay, can I wash my hands or whatever. I mean, where does that fit into the sort of, you know, reckless indifference thing? You know, in the sense that it doesn't seem like, I mean, obviously I know that he's not being charged with intentionally harming anyone. But the idea that you're sort of indifferent to the risk that you've created, it seems that that's kind of, that mindset is inconsistent with being so obvious about the fact that, you know, that this has happened, either that you did it intentionally or that, you know, this stuff is there.
Chief Justice Meany is taking that fact, the showing of the hands, drawing the inference most favorable to the state, that actually shows that what happened afterwards was a student who was frustrated. The inference from that is this was more actually frustration from not being allowed to wash his hands. And so that's why this deodorant gel was placed there. At least that's the inference that can be drawn from this. So it's not the inference that because he showed his hands, suddenly he's absolved, like literally washed his hands of you know, a sin here. It's the fact that he showed his hands, and then when the teacher goes off to, you know, help another student, she comes back and slips. That is indicative of more of intentional conduct, more reckless indifference for the safety of others.
And you think that an inference in favor of the state that somebody could have slipped, I mean, that's the inference we draw, right? That this substance is enough that somebody could potentially slip on it, and slip is the injury that, I mean, the action that results. That's enough to sustain culpable negligence criminally.
Your Honor, I mean, yes, it would be the exposure. There was exposure, but here, as my colleague conceded, there actually was actual infliction of personal injury. The teacher fell, hit her knee, and hurt her ankle, as she testified.
And what actually results from it, you know, the statute takes care of that pretty clearly. Yes. But in terms of culpable negligence, I mean, that's the standard that you want going forward, that if somebody could potentially slip, because that's what we're looking at. We're not looking at the resulting harm, I think you would agree, for determining whether an action falls into culpable negligence.
That's right.
So just the could have slipped is kind of the line that we would draw.
The line that you draw for reckless indifference for culpable negligence, as you alluded to earlier, is the foreseeability. You do look at some degree of foreseeability.
Right.
And
the evidence of that in the record is the could have slipped.
That's right. That's right, Justice Sasso. I'd like to continue.
Well, I mean, to be fair to you, oh, go ahead.
Go ahead. Go ahead.
No, go ahead.
I should say, I just clarifying this just a little bit. If he had dropped something to the science class, right? Let's say he had dropped something clear. I'm assuming this is clear. This deodorant gel. That's part of it. It wasn't visible. Dropped something clear, so not a milkshake, not something that would have been seen, but clear liquid. And it's like, I'm a 14-year-old boy. Walk away from it.
Mm-hmm.
How is that person also charged?
No,
Under
just,
this.
no,
And what is
just
the difference?
The difference is you're talking there more something of accidental conduct. Because
it wasn't accidental to not clean it up.
Sure, that part was not accidental. But first, the prime mover of that example is he drops it. And so what the student in this example does is he says, well, I think it'll be fine, or I think, it doesn't really matter. That is not so much the reckless conduct which would supplant the intentionality element as it would in the instance where, in our case, where it seems to have been done purposefully. So there it just seems something more like a simple negligence. It might be a little bit of gross negligence, for sure, but as this court's precedents have held, gross negligence would not be sufficient.
Well,
There is
the
that
issue would
distinction.
be, did he have a duty to clean it up, and did he intentionally fail to do that?
And
That's where the intentionality would come in.
Yes, Your Honor. So there would be that duty for the child to pick up and also it depends on where it was spilled to. I mean, it's a totality of the circumstances analysis. So there is that duty and it would be breached, but there it seems more something like a simple negligence.
I mean, do you admit that this case is close to the line of if you're above simple negligence, you're barely above it? Tell me why that would be an incorrect way of looking at this.
I'm sorry. Can you clarify the question?
Let's
you're referring
assume
to
that
this case?
let's assume that you're over the line of simple negligence. Would you consider this sort of like, barely over the line, or is this sort of the wheelhouse of what this statute was getting at?
No, Your Honor. This is a textbook example of what this
Textbook
statute.
example.
Yes, Your Honor. Yes, Your Honor. Because
This is a textbook example of reckless indifference to the safety of other people.
Yes, Your Honor. Because
Okay.
this is not close to simple negligence. This is not as if AC had dropped, in Justice Grosshand's example, dropped it and just didn't notice it and walked by, or noticed it and said, "Oh, okay, I think it'll be fine," or "I don't care." This is something more akin to intentionality. As far as the recklessness element, textbook as to culpable negligence as defined in Green. Maybe not so much textbook in terms of the harm done. Of course, this is just at the end of the day mere exposure to personal injury that we're talking about, but definitely the recklessness standard was met here by the evidence in the light most favorable to the state. I'd like to continue on to drawing on the error that my colleague makes in relying on Azima, Kish, and JC, because Azima is the first case that we see that the issue was culpable negligence, the same statute here. And what Azima did is it quoted Savares, which was a manslaughter case. And the issue with using the statutory and jury instructions for manslaughter is that the essential element is death. So of course it makes sense to define it in that context as a likelihood of death or great bodily injury because the end is
What's your
death.
response to the argument that the legislature's reference to death is just, we've already had the discussion about the legislature's clearly delineated different punishments for what actually happens as a result of the culpable negligence. And so what is your response to your friend on the other side's argument that culpable negligence is consistent across the statutes? In the manslaughter statute, it says the killing of a human being by culpable negligence. So we've talked about the result of what happened from the culpable negligence, but there's nothing wrong from a methodological standpoint to apply that definition consistently across statutes. And then the degree of penalty that's imposed as the result of the harm that occurs, the actual result of the harm that occurs, is why that additional language is in the statute.
Right. Justice Sasso, to be clear, the culpable negligence can't be consistent across the statutes because it's simply silent. in the statute. So, of course, it would come from case law.
Well, it could be. Yeah, I mean, you could use a consistent definition across all the statutes
Yes.
still, even though it's silent. So why would we not?
We would say that actually the imperi materia argument works better with our definition. Why? Because if you apply the likelihood of death or great bodily injury across manslaughter, felony child neglect, and then our statute here, what you have are acceptable results in the manslaughter and felony child neglect context because they contemplate death, manslaughter, felony child neglect, great bodily injury. Where it doesn't work is our case where it's just exposure to personal injury. Now, with the effect of that being there's disharmony and it limits the scope of the statute. Suddenly the emphasis is not on the exposure to personal injury. That doesn't do any heavy lifting anymore. The problem is now we look to the likelihood of death or great bodily injury, and that is not what the intent of this statute is, which this court said in Green.
Well, but the exposure is still doing work because it could be that you did something really dangerous and that you intentionally did it, but you just lucked out and no one was actually exposed to it.
Well, Chief Justice,
the thing is, the thicker the meaning of culpable negligence is, the less relevant the personal injury thing is, and then the more amorphous culpable negligence is, then the more you would maybe try to infer something about culpable negligence from the injury.
that's right, but the issue is that once you introduce that element, and really what it is, it's smuggling through the mens rea and rewriting the actus reus, because you smuggle in that element, and what the cases have tended to do is simply focus on either the harm or the likelihood of that, the great bodily harm or the likelihood of it. I'll give you the example of Azima. In Azima, the doctor implanted an IUD in a pregnant woman, and the court was simply focused on whether that harm, and although the testimony was that great bodily injury could happen here, the court reversed because it wasn't likely. And Azima was this misdemeanor culpable negligence statute. So the court paid no mind at all to the exposure part, even though it was actually exposure to great bodily harm, but instead said, well, the testimony was from another doctor that it wasn't likely. So that's the danger with going in that route. And back to Justice Sasso's question, the more consistent way to read the mens rea across manslaughter, child neglect, and our statute is to read it the way Green has defined it. Reckless indifference for human life or for the safety of others. Once you apply that definition consistently across those three, and I know manslaughter and child neglect is not an issue in this case, but that would be the more cleaner imperi materia way of reading this mental element.
But I don't know how productive it is to get into the sort of labeling stuff, but the culpable negligence kind of combines both the act, i.e. the creation of the risk, however you want to define the unreasonably high or whatever, and the state of mind, i.e. the kind of intentionality of the creation of the risk. So I don't think that, to the extent that if you're suggesting that the culpable negligence is just mens rea and then the act is the exposure, it's really, the mens rea is the intentionality, the act is the creation of risk, and then the exposure or injury is kind of a consequence. And I guess that's where the sort of labeling, uncertainty gets in. But you can't just sort of lop off culpable negligence and refer to that as quote unquote mens rea, because that also, the act that's being criminalized is part of that too.
That's right, and I don't mean to lop it off. That's just the way that the petitioners frame the issue. They're saying that the third confused the mens rea and the actus reus, but it really didn't, because, as you had said in your first question, in Section 4, the court devoted an entire section to determining the recklessness.
Well, not really. I mean, the opinion is very. I mean, the part where they actually get down to, they've done their work to establish the reckless indifference standard, but then when they get to actually applying it, there's almost no reasoning there, and there's no serious effort to kind of connect the evidence here to this test in a way that, if you read their opinion, that last paragraph reads like, hey, the person was negligent, therefore, and we've swatted down the serious, death or serious harm, therefore, game, set, match, it's over. I mean, that last part is really kind of inadequate.
To be fair, it is a a simple analysis that's done, and it's a string cite to the recklessness, the cases which have held it to be the recklessness standard, Green, JCM, and the like. But what I mean by my statement there, Your Honor, is that the court simply didn't just say, well, this was exposure to injury and therefore strict liability. No, it said, here, this is the standard that we're going off of, and then the state presented competent substantial evidence as to that point. And I see I'm running out of time here, so I'd like to conclude by asking this court to approve the 3rd District's definition of culpable negligence and to affirm AC's withhold of adjudication and judicial warning. Thank you very much.
Thank you.
So I'll concede my client's teacher probably would have prevailed in a simple negligence suit, but under the punitive damages standard from the Tesla case, which is a negligence case, she would not have been able to obtain punitive damages. And under the reasoning of Green, that means the evidence of negligence was insufficient to establish the crime of culpable negligence. For that reason, the trial court erred in denying his motion for judgment of dismissal. I know the state says I'm wrong about the punitive damages standard. My understanding of punitive damages in Florida is that there are 2 bases for them. There's intentional misconduct and gross negligence.
Yeah, and by the way, I mean, if we were going to go down that path, we would need to be reading punitive damages cases from the 70s when this statute was enacted, right?
Yes.
And the standard back then, I mean, it was very vague. It was essentially it was basically this block quote in Green.
It's exactly the block quote.
So looking at kind of the modern statute from the late 90s, I don't know that that's super useful for limiting the universe of what punitive damages are for.
So I understand Your Honor's point about the amendment to the statute or the enactment of the statute, but as recently as 2016 in Valladares versus Bank of America, this court held that the punitive damages standard from Caraway is the same one that still applies. So in cases where punitive damages are founded on gross negligence, it's still the same standard that it was in effect in the 70s. The 3rd District's decision in this case renders the reckless disregard for the safety of others standard meaningless. And if this court approves that standard under the facts of this case, it will criminalize ordinary workplace negligence like in Azima and in the example, the hypothetical I provided about the grocery store worker mopping and choosing not to put up the sign. It will criminalize childhood pranks like in JC or in this case, and those outcomes are clearly unconstitutional. This court should reverse the 3rd District's opinion and approve the decisions of the 1st and 2nd DCA. Thank you.
Thank you. We're going to take a 5-minute recess.
All rise. This honorable court is now in recess.
It's very different from the 3rd. Yeah.
I'm not rushing you. I'm just going to look this up.
I put the microphone up, but I didn't even realize it was adjustable.
looking for tomorrow, if it's going to be a bid hike. I'm tomorrow. Benjamin David. She's handling it. I know I did the evidentiary, but Mel's handling it. I know. This one they get through. This is when they get through it. Okay. You know. No. I know. Yeah. So, you know, this is not. I wish we had asked for it if we thought we needed it. Right? Is it automatically? Right. I mean, right.
All rise. The Supreme Court of Florida is now in session. Please be seated.
Okay, our next case is Smith versus State of Florida and Smith versus Secretary, Department of Corrections, numbers 2024-0873 and 2024-1549.
Good morning. May it please the court. My name is Melody Jackway, and I'm here on behalf of Donald Smith. Now, this is a capital post-conviction appeal appealing the denial of the post-conviction court's denial of Mr. Smith's 3.851 motion. Now, while we have addressed several claims within our brief regarding both the guilt and penalty phase, we will be focusing on Claim 5, in which he was denied effective representation during the penalty phase by trial counsel calling and eliciting prejudicial testimony from Dr. Heather Holmes. Now, we stand on our claims in the rest of the brief, but this will be our focus. Now, the aggravated nature of the facts of this case make this case the perfect case to look at and determine what it means to have effective representation, especially considering the aggravation, and what it means to present mitigation in this case. Now, trial counsel failed to provide effective representation when they enlisted a strategy, elicited testimony from Dr. Heather Holmes that prejudiced Donald Smith and exposed the jury to very prejudicial testimony and facts and evidence that they otherwise would not have heard of.
Can you go to the strategy part first? I mean, the evidence is that she knew that it would be controversial, but it's something that she thought long and hard about, and thought that essentially the risk was worth it. So, from a Strickland perspective, why do we discount that testimony?
Now, the strategy that was stated, the central theme of the strategy that was stated by trial counsel was that Dr. Heather Holmes, the testimony that they wanted to elicit from her is that she would be an indictment upon the system of a failed Jimmy Rice system, that Donald Smith should have been involuntarily civilly committed under the Jimmy Rice Act. Now, that strategy, although controversial, could also be interpreted as unreasonable because the testimony that was elicited by trial counsel had very little to do with whether or not Donald Smith should have been involuntarily civilly committed under Jimmy Rice. When looking at the actual testimony that was elicited by trial counsel during the direct examination, the trial counsel elicited from the start of the direct examination, elicited from Dr. Heather Holmes information asking about whether or not Donald Smith was incompetent, whether or not he was insane at the time, and then elicited whether or not there was any mitigation from Donald Smith that Dr. Heather Holmes was able to get, to which elicited the response from the defense expert that there was nothing that was mitigating about Donald Smith, that there was nothing that was indicative of mental illness other than the diagnosis. And so the strategy, if it was the strategy, it's seen very little as a central theme in the penalty phase, both seen in the opening statement of penalty phase. It's mentioned briefly as that Donald Smith fell through the cracks. It is seen very little from the actual direct examination and redirect from Dr. Heather Holmes, and it is seen very little within the actual closing argument of the penalty phase. And so if this was a strategy, it certainly does not appear from the record itself that it was a central theme as stated during the evidentiary hearing.
So that's I guess from a Strickland deficient performance perspective though, we would basically need to discount the testimony of all the background on the strategy and kind of conclude that that was almost like an intentional, they knew that this testimony would be elicited and went forward with it anyway. I mean, when we need to conclude that in order for it to rise to the level of deficient performance?
I don't know that the court would need to discount the fact that it was stated that it was a strategy. I don't know that the court would need to do that. I do think, though, it would be that the court would need to determine whether or not that's a reasonable strategy. And we're not talking about necessarily an unusual strategy. It would be unreasonable for a penalty phase strategy to present to a jury, the fact finder, an illicit testimony that essentially blaming the state of Florida. That's essentially what trial counsel was trying to do, was blaming the state of Florida that Donald Smith was not involuntarily committed under the Jimmy Rice Act. A reasonable person would find that unreasonable.
Isn't Strickland, though, I mean, the reasonableness language is in there, but it's essentially, it rises to the level that they weren't acting as counsel constitutionally. So it has to be something more than, that somebody might disagree with the strategy, right? And that essentially nobody, that it was completely unreasonable strategy, that there was no basis for it, that sort of thing, right?
That is one aspect of prong one. The other aspect of prong one under Strickland would be that it falls below the professional norms and standards. Mm-hmm. And it is our argument that it would fall below the professional norms and standards, especially given the prejudicial nature, which I've stated, the questions that were elicited by trial counsel. In addition to that argument, another consideration for this court is much of Dr. Heather Holmes' testimony, in fact, contradicted many of the 60 non-statutory mitigators that were presented by trial counsel. And it would certainly fall below the professional norms to present a defense witness that is going to directly contradict a number of the mitigators that you're presenting to the jury.
But isn't, from the standpoint of professional norms, isn't really the lodestar the quality or degree of weighing or investigation, the thoroughness of consideration? I mean, the standard can't be that strategically, with 20/20 hindsight, we disagree with it and therefore it falls before a professional norm. I guess what I'm asking to follow up on Justice Sasso's question is, was the trial court wrong when it concluded, this is page 48 of your brief, quote, that Dr. Holmes, that the decision to call Dr. Holmes was, quote, reasonable though risky and chosen only after thorough investigation and careful consideration of other mitigation presentation strategies, unquote. Do you quarrel with that finding? Was the court wrong that, in fact, counsel made a choice after investigation and consideration of other mitigation strategies?
So to answer yes.
The trial court is wrong.
The post-conviction court is wrong in making that finding, but if we take that strategy was reasonable, if we take that.
Remember, my question is whether the inquiry here for Strickland purposes is, do I look to see whether the counsel thought about this, whether counsel investigated, whether counsel put in the work and decided this is the strategy we're going to take, not this is 2020 hindsight and we're judging the strategy and deciding it falls below what I would have done as counsel. It seems to me like the Strickland inquiry is the former, not the latter, and I'm trying to see whether you agree with me.
I do agree with you to a certain extent. I do agree with you that it would be whether or not part of Strickland is whether or not a strategy was investigated, the investigation, mitigation, and so on. The other aspect of that, though, is it certainly would be ineffective and certainly would be deficient performance to then elicit testimony and expose a jury to testimony and facts and evidence that they would not have otherwise heard. For example, hearing from their own defense witness, direct testimony that contradicts a number of the statutory mitigators. For example, when asked by the state and then trial counsel did not follow up on about Donald Smith's brain injury, whether or not there was any organic brain injury and if he had any abnormal brain functioning. That contradicts one of the statutory mitigators. Whether or not there was anything regarding his sexual developmental history, such as him being sexually molested at the age of 8, whether or not teenagers forced him to watch them violently sexually molest several girls, whether or not he revealed this sexual abuse to his mother, whether or not his mother had suspected that an uncle of his had molested him, whether or not he had received any treatment. I mean, and I can go on. There were several things that fall below the norms of the standards of professional norms. And so
the introduction of it falls below the standards of professional norms. The strategic decision to introduce these things, you're saying, could never have been a reasonable strategy by counsel.
It would not be reasonable.
Could never be. That's kind of, remember, I mean, our test is not that it didn't work out. Our test is, this is malpractice. And I sort of go back to where I was before. My question for you is the trial court wrong when it found that counsel considered these things and made a choice that now perhaps Mr. Smith wishes counsel hadn't made? That's different, though, from counsel heedlessly throwing a dart at the board, stupidly, without considering things, introduced this evidence into the record. Was the trial court wrong that, in fact, the counsel thought about this?
It's clear from the post-conviction record trial counsel thought about it.
Okay.
Now, when we're talking about the actual strategy, it's important that we focus on what the strategy was. Trial counsel elicited this strategy of calling Dr. Heather Holmes because of her expertise in sexual offender and sexual predator evaluations for involuntary civil commitment under the Jimmy Rice Act. It was trial counsel's strategy to then say that because the state of Florida, Department of Children and Families, the state attorney's office, because they failed to involuntarily civilly commit Donald Smith when they had the opportunity to, dating back to about 2006, 2007, when the date of this offense was in 2013, that but for their failure to involuntarily civilly commit him, he would not have had the opportunity, and Cherish Perry Winkle would still be here today. That is an unreasonable strategy, to place blame in front of a jury that the state of Florida is what gave Donald Smith the opportunity to commit this crime. That is unreasonable, and I would believe that would always be unreasonable, especially given these facts. Now, I hope I answered the court's question.
Yes.
Now, in looking at what trial counsel knew from the deposition, because Dr. Heather Holmes was deposed, and a number of prejudicial things came out during that deposition, which trial counsel was aware of. They attended the deposition, they were aware, and they then opened the door for the state of Florida to then cross-examine on a number of issues that far exceeded anything to do with a Jimmy Rice evaluation. For example, the trial counsel asked specifically about why they had contacted this defense expert, and the expert testified that she was contacted to see if there was anything mitigating about Donald Smith. Now, that then allowed, on cross-examination, the state to seize, and I'm using the words from the post-conviction order, the state seized on the opportunity to then cross-examine and ask Dr. Heather Holmes, the defense expert, whether or not there was anything mitigating about Donald Smith, to which she replied, there is nothing mitigating about him. Now, to compound the error that occurred, trial counsel did not cross-examine or impeach or rehabilitate their witness on redirect, going through a list of a number of things that would be mitigating. Going back to the sexual development of Donald Smith, it is clear from the post-conviction record that Dr. Heather Holmes was aware of the abuse that Donald Smith had reported from when he was 8 years old and as a teenager. Trial counsel did not ask, would that be mitigating? Would being sexually molested at 8 years old be mitigating? Would having a stepfather who's sexually inappropriate with you, would that be mitigating? Would, I apologize for a moment. Would having brain damage be mitigating? Would mental illness be mitigating? And going down the list of a number of things that were listed as mitigators. Now, going back to trial counsel opening the door, they also asked about whether or not she talked about the facts of the case with Donald Smith, which then allowed the state on cross-examination to go through the facts of the case on penalty phase all over again, and asking one after another each question, in which trial counsel opened the door to, had they just kept it, if we take that the strategy about Jimmy Rice was reasonable, if we take that as a reasonable strategy, asking questions that exceeded the scope of anything to do with Jimmy Rice, that exceeded that scope, was deficient performance. And it was not fixed, and it was not corrected on redirect. Now,
is it your position that this was made or worsened by the fact they already knew this was a risky witness?
Yes.
So they knew they were calling someone that was already, they weren't really sure they should have, and they called her, and then they opened the door. Do you think that that makes it a little bit different than just sort of what we would see of just randomly opening the door?
I do agree with that. Yes, I do. And it compounds the error. The scope could have been limited if we take that strategy as reasonable. The deficient performance comes from opening the door wide open and, of course, allowing the state to just walk right through it, which, of course, they would, and just go through the facts of the case, go through that there's nothing mitigating about him. So to answer the question, yes. Yes, it would. Now, I would like to reserve the rest of my time for rebuttal if there are no other questions. Thank you.
May it please the court, Assistant Attorney General Charmaine Millsaps representing the state. I'd like to clarify some things about Dr. Holmes. She wasn't the only person presented in support of blaming the state for not Jimmy Ricing him when the state had two opportunities to do so. one in 2002, which was dropped by the state attorney's office. That's not the one that Dr. Holmes is, the 2006 one that Dr. Holmes was. But it was not just Dr. Holmes that was called by the defense. It's also Attorney Bozen who was called to lay out all the stuff about this. So when you look at it, you have to put them together to see the defense, because some of the details were brought out in the attorney's presentation instead of Dr. Holmes. Regarding whether this was a reasonable strategy, first of all, I'd like to back up, and before we even get to reasonable strategy, you have to look at what other strategy is available to counsel. And unfortunately here, there was very little clean mitigation available. There wasn't another, it was basically this or not quite nothing, but then, for example, you would be left with the mental health, with the three neuro experts, the prison guard, and the son, which the jury found only the son to be mitigating, and that was not powerful mitigation because the relationship with his son had developed once he was incarcerated for this crime. So it wasn't like he was a good father for 40 years. You need to look at what's available to counsel before you say this never should have been done. And it would boil down to do this, or you're left with basically just the son. And then I'd also like to talk about the investigation here. They had both an investigator and a mitigation specialist. The mitigation specialist talked to approximately 50 people, some of whom were not even willing to talk to her. But most of them, they would talk to her, but none of them were willing to testify. So prototypical lay family mitigation was not available. Donald Smith did not want his mother called, and his father had dementia. So at the immediate family, only the son was really readily available to them. And so there was very little mitigation to be had. But this was a thorough investigation, and a decision made after a thorough investigation by two experienced attorneys making these decisions. Two attorneys who not only experienced in criminal but in capital cases making this decision, and they consulted with other people, although it wasn't clear what the other experts such as Skull said about whether this strategy should be used. I disagree that Dr. Holmes' testimony was contradictory on the brain. One of the other areas of mitigation they went in is they presented 3 neuro experts, and based on MRIs, they testified that he had abnormalities from his MRIs and PET scans. But yes, Dr. Holmes did say that the EEG showed it was normal, and she did say that. But that's a fact given. That's not her opinion. She was not doing that EEG. That was from Dr. Miller decades earlier, and another doctor, 2 doctors earlier. That was just a fact in this case that everybody knew about, including the prosecutor. It was not her personal expert opinion that he did not have brain normality. She was talking about a report from Dr. Miller and another expert decades earlier, which everybody knew about. And their way to try to get around that EEG was to hire new experts with newer tests, the MRI. I'm going to mispronounce his name, but Dr. Colina did a MRI and testified that that Smith had brain abnormalities. Okay, but it is not, you cannot place that at Dr. Holmes's feet. That's not her opinion. That's a given. That's a factual given in this case. That is a historical fact in this case that the prosecutor can use to cross-examine any of the three neuro experts that were presented. So this was a thorough investigation, both by her, the investigator that they had, and Dr. Brooks, the mitigation specialist.
What is your response to the argument, but essentially the failure to rehabilitate after this information came out?
To rehabilitate her?
Mm-hmm.
Well, I'm not sure what she really means by rehabilitate. The deposition, I don't think, opened the door. Remember, when you put on a mental health expert, that automatically opens the door to any other mental diagnosis that he has.
Well, I don't think that's what she's talking about. I think what she's saying is, there was this reasonable or unreasonable trial strategy, but certainly a risky one.
Yes.
Then you take a witness that you know from your deposition has answers that don't line up with all of your other evidence. So that's a little risky, but you make that choice. And then in front of the jury, you ask a series of questions that goes beyond her, why you called her, and then opens the door for the state to then ask all these other questions, which they're entitled to do. And then you fail to go back and try to rehabilitate or fix anything in front of the jury. So what would be your response that is not deficient?
Well, I still think that it's not. The depo happened about 3 weeks before trial. And even if you decided you would be then limited to the attorney Bozen. Remember, she does serve a unique role here. She's the one who's an expert in Jimmy Rice. She's the one who can testify that the expert who was part of the 2006 aborted Jimmy Rice, his expert report, she said she was exquisitely surprised that if Smith didn't qualify as somebody who should be Jimmy Rice, no one would. Okay, so she does have that role. So if you want to attack the basis of that 2006, you need somebody like her. And so I just think that the prosecutor would have asked most of those questions regardless. Some of this is going to come out no matter who it is. And some of it's going to come out, the prosecutor is going to use some of this even if you didn't present a Jimmy Rice expert. He's going to cross your neuro people about the old findings about not finding any brain damage. You can't really limit a mental health expert to your diagnosis is X and think the state can't talk about diagnosis as Y and Z. Yes, we will cross, and we'll cross no matter who it is. And yes, she was, and they were trying to be careful with her, because even though she called him dangerous, at the evidentiary hearing she went even further, and she said this was one of the 5 most. She had examined approximately 2,000 people, and this was one of the most dangerous psychopaths. I think she said one of 5 out of those 2,000 that she would put in that category. So they were trying to make sure that that they didn't want to cross her too much to get the prosecutor to really get at that fact. How dangerous is he? How many people have you examined? The prosecutor could have asked that question regardless. So I am not denying that this was a high-risk strategy. Counsel admitted this was a high-risk strategy. The panel, guilt-phase counsel called it a Hail Mary path. Okay? It's this or nothing. And whenever Hail Mary passes usually fail. And that's because they're hard to do. But it was really this or nothing. None of the mental health experts, the jury didn't find any of that mitigating, any of those 3 neuro experts. It was only the son they found mitigating. There just wasn't a mitigation case. There wasn't a good mitigation case to be had. And counsel's not ineffective for deciding to do this instead of nothing.
So
And there's also no prejudice.
Yeah, I was going to say, if you're right about that, then the prejudice thing becomes an insurmountable problem for the other side.
Yes,
right?
it really does, and it is here. Remember, 6 aggravators were found, including 3 of the most serious. And the judge gave great weight to the CCP. Oh, and the prior violent felony, the state put on one witness in its penalty phase, the victim of the 1993 kidnapping. Her testimony was just devastating to a case for life. You had an adult woman speaking with an adult woman's maturity about the terror she felt when he tried to kidnap her. And you know what the jury was thinking. It was just she ingeniously ran 2 places. He followed her in his van, and she hid in a tube slide, so he didn't realize she was in the playground. It's just an amazing story, and it's devastating because you now know that he is the jury now knows not just what they already convicted him of, but that he's a recidivist sexual offender. And they're hearing it literally from the mouth of an adult woman about a crime that occurred to her when she was 13 years old. And they're thinking, but for the grace of God, go her. And quite frankly, after that presentation, it would have been very difficult. I don't see how any attorney could have won this case. I just don't see it. And I don't usually, go that far, but when there's nothing available, and that's what counsel's facing. This was a perfectly reasonable strategy, and there's absolutely no prejudice. Thank you.
Thank you.
It's important for this court's consideration to consider that the jury heard, as the state has said, the very impactful testimony of a now adult victim who ran from Donald Smith as a child, and immediately after, the first witness that was called by defense was Dr. Holmes, to which then they heard things such as, from trial counsel asking, is this something that somebody chooses? Is this something that, the pedophilia, is this something that, is caused by something? Which then elicited from Dr. Heather Holmes, I don't believe that there's something that you're born with. We believe that it's something that develops. Something goes away during the developmental period. And then trial counsel then immediately after that question asked her to clarify. Trial counsel asked, excuse me, was there anything about the social history that you obtained from Mr. Smith that gave you insight as to how it is being referred to as pedophilia developed and magnified so much in Mr. Smith? To which defense elicited the following response. It's certainly the continued drug use is going to make somebody less likely to resist their inhibitions. So I would love to say that there's one defining moment in a childhood, and he certainly had an inappropriate relationship with his mother, and a lot of people do, and they don't turn out to be pedophiles that murder a child. That testimony was elicited by trial counsel.
Do you want to address prejudice? I see your response to the clean mitigation argument in the reply brief, but specifically prejudice in light of the mitigation that was found. Just address the prejudice argument in that context.
Certainly, we do not know what juries will do. We do not know what juries will do. But the more aggravated a case is, certainly aggravated as this, mitigation becomes even more important. And so we don't know, because we don't have hindsight, as to what would have happened had the jury had absent this prejudicial testimony. What we do know is that this testimony did not assist in the mitigation, and we know that from the jury not finding many of the mitigators, and so this certainly was not mitigating in this case. I hope I answered your question. Now, as to the connection that Dr. Heather Holmes made between the evaluations and Donald Smith, there was never an actual connection that was made between whether or not those evaluations that he had would be sufficient for him to be involuntarily civilly committed. What specifically trial counsel asked is whether or not she found it unusual that he was not involuntarily civilly committed. Unusual. Unusual, the word unusual, and saying that this person should have been involuntarily civilly committed are different. Those are different statements. And so while there was the attorney who testified, Attorney Bozen, who testified after Dr. Heather Holmes to make the connection and explain the process of Jimmy Rice and involuntarily civilly committed, even under the strategy, if this court finds it reasonable, there was never a connection made between the evaluations and Donald Smith. And it wasn't just the most recent evaluation that Dr. Heather Holmes was looking at. There were evaluations dating back to 1976. And so for those arguments, the court has no further questions. We would ask this court to reverse for a new penalty phase. Thank you.
Thank you very much. You're excused. All right, we've reached a bittersweet moment in our day here. As we mentioned earlier, and as you know, Justice Charles Kennedy is going to be retiring from the court at the end of this month and starting a new chapter of public service at the University of Florida's Hamilton School. Justice Kennedy has been a truly remarkable public servant. He is a great Floridian. He started his public service with 3 terms in the Florida House. Then he served 4 terms in Congress. Then he was an extremely effective general counsel for Governor Jeb Bush, and I can say that because I was there for every minute of that. Then he served almost 6 years on the 2nd DCA, and he has been a member of this court since 2008, including 3 terms as Chief Justice. And I mention all that just to sort of set the table, to give people a sense of the extent of his service, but it's not just about the quantity, it's also the quality. When I think about judicial excellence, I think about Charles Kennedy, and the entire, I think there are countless judges in Florida who are better judges because of your example. I think that the jurisprudence of our state is better because of your service. You've been such a great friend and a person of great integrity. I think it's no accident that we have so many people who've come here to hear your remarks today. We're very happy to be joined by Representative Jennifer Kennedy, your wife, by former Justices Polston and Lawson, and so many of your current and former colleagues. So I know that I speak for everybody on the court when I say that it's really been an incredible blessing for us to have served with you. You're a role model for all of us. You're a dear friend. We love you, and we look forward to your remarks.
Well, thank you very much, Mr. Chief Justice. I appreciate those very kind remarks, and I do appreciate this opportunity. The thing I ask at the outset is that any of you that are praying people, pray that I maintain my composure, because I tend to get emotional on occasions such as this. But pray, please. I've always been grateful for the opportunity to serve the people of Florida as a justice of this court. But I have never felt the sense of gratitude more keenly than here today as I've come to this bench for the last time. What a great privilege it has been to participate in the work of this court, in the great project of giving life to the rule of law. Words truly fail. I know that's a kind of a tired phrase, but words truly do fail me in expressing how much I owe to all the people who helped me come to this court and all those who have helped me in my service here. Now, today, I can't personally identify everyone I would like to thank, but there are some people I cannot fail to mention. I began my journey as a judge when I was appointed to the 2nd District Court by Governor Jeb Bush. But for that appointment, it is unlikely that I would have ever made it to this bench. I will always be grateful to Governor Bush for opening the door for me to serve in this branch which I love so much. And I would also most likely have not received the appointment to this court, but for the support of the 2 Jasons. And I don't know if either one of them are here, but they may be out there listening. Jason Unger, who chaired the Supreme Court J&C, and Jason Gonzalez, who was Governor Chris' general counsel at the time of my appointment. I hope that my work here has justified their confidence in me, even when I have found it my sworn duty to rule against them, which has happened. At the court, I have been blessed to have wonderful staff. My 2 longtime staff attorneys, Renee Urban and Tom Kovacek, are truly extraordinary. And I am confident that the 3 judicial assistants that served me, Pam Stewart, Jessica Outlaw, and Brenda Williams, are the very best in the history of this court. And I would talk about them, but I would lose my composure for sure. Our whole court is very fortunate to have some very dedicated and capable people on our staff, including our very able central staff, all the people who make it possible for us to carry out our work as justices. I want to particularly mention Paul Fleming, who's our public information officer, and Diane West, who heads our central staff. They are such wonderful people and such a delight to work with and serve the court so well. I also want to give thanks to everyone who helped me over the 3 terms that I served as Chief Justice. It was such a privilege to work with clerks Tom Hall and John Tomasino. It was also wonderful to work with Marshall Sly Dawson, who has been succeeded by our very able Marshall Woody Curse. And to all of the chief judges and other judges who play a part in the governance of our branch, it has been such an honor to be able to work with you when I was chief. And there are just so many people involved in the governance of the branch. Those of you who know about how our branch is governed, you know it's not just us. There's a wonderful team of judges all across the state who are involved in that project. And among those judges, there's all the chief judges that I had the opportunity to work with as when I was Chief Justice. I need to single out especially Judge Lisa Munyon and Judge Robert Morris. Judge Lisa Munyon served so ably chairing the work group during the pandemic that provided recommendations to me to help us navigate that process, and I'm very grateful to her. And Judge Robert Morris has done so much in the leadership of the branch and in working to help improve the administration of justice for the people of Florida. So I'm deeply grateful to them and all the people that they worked with to accomplish the things that we were able to accomplish. Now, of course, none of the courts in this state could function without the administrative support provided by the Office of the State Courts Administrator. Now, I've sung the praises of Lisa Keel many times for her outstanding service to our courts, but I do it again today. I have never met a better public servant than Lisa Keel. Our courts could never have navigated through the pandemic as successfully as we did without Lisa and her wonderful team. We are fortunate today that a key part of that team, Eric McClure, now serves as State Court Administrator with great distinction. Now, in the book of Proverbs, we are told that wisdom is with those who take advice. We're also told that iron sharpens iron. And I think those two proverbs really sum up the appellate process. It sums up the role of the lawyers, but also the role of the judges who work as a collection of minds. And I cannot say how much I have enjoyed working with all the judges I've served with, both on the 2nd District Court and on this court, who have been here to do the work of justice. I have learned so much from so many of them, and I have found my colleagues to be such a wonderful group of people. And the group of colleagues I have now, again, I will lose my composure if I talk too much. Because I do love them all. They are wonderful people, they're dedicated, and it's been such a privilege to work with them. And I'm very grateful that Justice Polston, former Justice Polston is here, and former Justice Lawson. They were wonderful colleagues. Justice Polston and I were here from the beginning until not too long ago when he left. He got out the door a little ahead of me. And so I was so grateful for the time that we had together as colleagues, and for the friendship of the two of you. And thank you for being here. Now, I'd love to talk about all the people on the bench here today with me, but I have to mention George and Carlos. I'm not going to say much because I know I won't be able to avoid totally losing my composure. But I just wanted to say to both of you, I hope you know what our long-term friendship means to me. I will always treasure it. And to the rest of my colleagues here, thank you so much. I love all of you. And we will not be strangers. I really hope that we will have the opportunity to spend time together going forward. Now, not too long ago, I read something that pointed me to a poem by Robert Frost. Now, I'm not sure I've ever quoted poetry here on the bench. I may have, but it wouldn't be impossible. But the poem that I was pointed to says this: "My object in living is to unite my avocation and my vocation, as my two eyes make one in sight." Throughout my professional life in public service, I have been able to unite my vocation with my avocation. And that is a special privilege. There are other people, obviously, who have that privilege. I think all of us do, really, here on this bench, and in other professions, in lines of work, that's possible. But this is just, I would do this job, if I didn't need to make a living, I would do this job for nothing. It is just an honor to be able to do this job. And I now feel very privileged to be going to another position where I think I can also say that I will be uniting my avocation and my vocation. I see the next chapter as an extension of the public service that I've been involved in here at this court and in the earlier chapters in my life. So I'm very grateful for that. It's not always that someone at this stage in life gets a new chapter that's exciting, and I'm very grateful for the opportunity that I'm going to have at the University of Florida in carrying forward the values that I've tried to stand for here at this court and taking those to the coming generation. So thank you all for allowing me this opportunity. Thank you all for your friendship. Thank you for the work you do for our wonderful state, and God bless you all. Thank you.
Justice Kennedy, thank you so much for those remarks. And we commit to you and to the people of Florida that we will work as hard as we can to live up to the high standards that you have set for us. Thank you very much. We're adjourned.
All rise. This honorable court is now adjourned.